You prepare for weeks, step into the courtroom, and the judge makes an unexpected ruling that guts your entire case. Most people respond by complaining that the judge believed the other side, a credibility call that reviewing courts are rarely willing to overturn. We are going to translate that raw frustration into a legally viable 9-point document called the Abuse of Discretion Worksheet. To start, you need two things. First, grab your hearing notes or the official transcript. Second, open a blank digital or physical document. This framework takes your initial reaction out of the equation. It forces you to stop venting and start building a systematic, objective case. Look closely at your notes. We need to identify exactly how the judge handled your specific piece of evidence. This diagram shows the two paths your evidence can take: discounted or excluded. If admitted but the judge simply didn't believe it, that's discounted. Because the law gives judges latitude to weigh testimony, these are difficult to challenge. But if the judge outright blocked evidence or stopped a witness, you are on the excluded path. This provides the legal opening for an abuse of discretion challenge. Think of a judge's discretion like a target range. Acceptable options are inside, but an abuse of discretion happens when the judge chooses point Z, completely outside the law's boundaries. To prove this, anchor your challenge to one of three core legal theories. 1. The judge applied the wrong legal rule. 2. They failed to consider mandatory legal factors. Or 3. The ruling was completely unreasonable in the circumstances. By selecting a precise theory, you make the appeal about objective legal mechanics, removing any subjective attack on the judge themselves. Even with a strong theory, higher courts will refuse to fix a mistake if you didn't challenge it correctly in the moment. This requirement is called preserving the record. First, check your transcript to verify you made a specific, timely objection and secured a clear ruling from the judge. If your evidence was excluded, your transcript must contain a specific procedure: the offer of proof. An offer of proof means you stated on the official record exactly what the blocked evidence or testimony would have shown, so a reviewing court can evaluate it later. Proving the judge made a mistake is only half the battle. You also have to prove that mistake caused actual harm to your case. In legal terms, this is called prejudice. We calculate prejudice using a 4-step formula. Step 1 identifies the specific item that was excluded, and Step 2 details exactly what it would have proven. Step 3 connects that proven fact directly to the specific judicial finding it contradicts. Step 4 requires you to explain how changing that finding alters the final outcome of the case. Without demonstrating quantifiable prejudice, an appellate court will classify a judicial mistake as a harmless error and dismiss your challenge entirely. Now, bring up that blank document. We are going to assemble your final 9-point worksheet. Points 1 and 2 lock in the event. Quote the exact ruling the judge made and note the specific timestamp when it occurred. For points 3 and 4, document exactly what exhibit or testimony you offered and the precise reason the judge gave for rejecting it. Next, record the specific objection you made on the record and summarize the offer of proof you provided. Points 7 and 8 apply the formula. Detail the specific judicial finding this impacted and calculate the resulting prejudice to your overall case outcome. Finally, for point 9, cite the exact transcript page and line numbers to guarantee your claims are supported by the record. A critical warning: do not use inflammatory language. Claiming a judge is biased requires an extraordinarily high burden of proof. Stick to clinical facts, stating that the court misapplied evidentiary rules. Completing these 9 points strips away the emotional baggage, leaving you with a precise, technical record of the court's actions. You have just taken a messy, overwhelming courtroom loss and restructured it into a precise, targeted tactical document. You can now deploy this worksheet to anchor a motion to reconsider, file a motion for a new trial, or hand it directly to an appellate attorney to accelerate their review. But you must act quickly. Deadlines for post-hearing motions vary by jurisdiction and case type. Check your local court rules immediately. The courtroom floor can feel chaotic and stacked against you, but mastering the mechanics of discretion restores your power to fight back systematically.